Hi, I'm John Napolitano, the CEO of U.S. Wealth Management. Today we're going to talk about what happens to the assets of your children when they get a divorce. When they are in the process of divorce, it's likely that all of their assets will become a part of what's called the marital estate and available for settlement. Now, that may include any assets that were gifted by you, inherited from a family member, or currently co-owned with anyone. This may be cause for regret later on when they learn that some of those assets could have been excludable from the marital estate with just a little bit of advanced planning. The simplest way to protect important assets or family assets, such as a business or a legacy home, is through a prenuptial agreement. These agreements are signed before a marriage and may exclude any particular asset that the couple agrees to. However, it is possible to execute an agreement like this after the marriage. There may just be a few extra nuances to that process. Now, absent a prenuptial agreement, a different method to protect assets from a future marital issue can be achieved by the method that you use to bequeath those assets to the next generation. Commonly, people leave their assets to a surviving spouse, with the remainder to be divided equally amongst the children after the passing of that surviving spouse. Now, I understand the equal part, but I don't understand why advisors leave their clients' assets out there and vulnerable to a future marital issue. This is particularly important in regard to operating a business or any assets that will be owned and operated by more than one child after your passing. The divorce rate is still around 50%, and it's negligent to believe that your children's marriage cannot fail. Furthermore, asset protection can protect for issues beyond divorce, such as a lawsuit against your child, maybe a major illness. You shouldn't feel bad disinheriting your child's spouse, especially if there are grandchildren involved. Imagine your son passing away prematurely, with the inherited assets then passing directly to his wife. Should your daughter-in-law get remarried, her new spouse is likely to inherit the assets should she pass, thereby disinheriting your grandchildren. I'm sure this isn't what you had in mind. The fix to this is to establish trusts to inherit the assets for the benefit of your children, with the protections of an independent trustee and a few simple rules. This strategy is most important when it comes to family business assets or other assets where the legacy is your intention. You may be healthy today, but that isn't a good reason to delay and have a subpar plan for your heirs.